Right, we need to evaluate and criticise the defences of duress by threat, duress by circumstance and necessity. So we'll start with duress to begin with and make some brief notes on that. The biggest criticism that's levied against the defence of duress is that it's not available to a charge of murder, and we know that from the case of Howe. This becomes particularly problematic because if a defendant is convicted of murder, they must be given a mandatory life sentence. The judge has no discretion about what sentence he gives. He has to give a life sentence. He can, if there is a mitigating circumstance, he can bring the tariff, the amount of time spent in prison, slightly down, but they will still be serving a life sentence. So, in situations like this one, that can cause a bit of a problem. If you just take a moment to read through that. So you might remember that in law there's a rule, joint enterprise is one of the rules, that if you join up with somebody else to do something, you are held equally guilty for the end result. So just because he's the getaway driver and didn't actually pull the trigger or whatever else actually happens, doesn't mean that he's any less guilty than the person who did pull the trigger. He would be he would be tried for murder in exactly the same way as the person that did go into the bank or wherever and shoot somebody. So, in this situation, we might have some sympathy for this defendant, but the court would not allow this defendant to use the defence of duress. So he would be convicted of murder and would face that mandatory life sentence. So it seems a little unfair. So a couple of judges have been asked to comment on it. And the first is Lord Hailsham. You don't need to remember his name unless you particularly want to, but his idea was that actually you should never value your own life above somebody else's. So he basically thinks that this motorist should be a hero and accept that they have to die rather than go and take somebody else's life or assist somebody to take somebody else's life. Some people would suggest that maybe Lord Hailsham's asking more of people than they can give there. It was further criticised. They talked a little bit more and said, well, imagine if this had been a mother driving a car with their two children in the back, and instead of threatening the driver, the person doing the threat threatened to kill the two children. Would you still expect that mother to be able to value somebody else's life above the lives of her two children? And perhaps that is asking too much. Lord Griffiths says it's not a big deal. We shouldn't worry too much about this because actually the CPS only prosecute when something is in the public interest, and prosecuting a motorist in these circumstances wouldn't be in the public interest, so we don't need to worry. I'm a little bit dubious about that, as you may be too. So, it's also a little bit incongruous in that you can use the defence of duress for a Section 18 GBH offence, and you can walk free from court because duress is an absolute defence, even though the intent to do GBH is the mens rea for both of those offences. For both murder and Section 18, you can be convicted on the same state of mind that you intended GBH. So if a defendant who has done a Section 18 can use duress, and somebody who's just had a bit bad luck, exactly the same state of mind, but their victim has actually died, is not allowed the defence, then it seems a little bit inconsistent and unfair. For all of these reasons, the Law Commission has at least twice suggested that duress should be a defence to all crimes. And it'll be no surprise for you to learn that as yet the Law Commission has been ignored on this point. So the second criticism about duress is that this objective part of the test is unjust. The part that asks whether a sober person of reasonable firmness sharing the same characteristics would have done the same. It is a mostly objective test, aside from the characteristics that Bowen has said can be taken into account. And that list of characteristics did not include having a very low IQ or being particularly vulnerable to threats in any other way. You'll remember, and you can look back at your notes, it did include things like being female or being pregnant or being disabled, but definitely didn't include low IQ, which was what Bowen was all about. Now, that does seem a bit unjust and unfair, because a defendant with a very low IQ may find it more difficult to withstand threats that are being made to them. And most other areas of law will take into account somebody's vulnerability, and a lot of the law that we look at are subjective tests, because it's about how blameworthy we find this particular this particular defendant. But here that's ignored. So you may or may not propose that actually those people with low IQ should have that taken into account in that objective part of the test. Thirdly, the threat must now be immediate. So we previously had the case of Hudson and Taylor, the girls who were testifying against some really quite nasty, violent people who had their friends in the public gallery making throat-cutting signals across the room, suggesting that if they carried on talking, then they would be seriously hurt afterwards. So the girls lied, stopped telling the truth in court, which is a criminal offence. The threat against them wasn't immediate, because obviously being in the courtroom, the people in the public gallery weren't going to leap across with all the security there and start attacking the girls there and then. It was going to be later. But that was considered okay in Hudson and Taylor. They were allowed to use the defence. However, Hassan has now changed that, and it now has to be a threat that's going to occur immediately. So if that same event was to occur now, and the girls felt unable to immediately ask for help, they would be stuffed, really. They would be denied the defence of duress. On to evaluating necessity now then. So the first point is that in the case of Bukoki, the judge pointed out that emergency service drivers, police, ambulance, fire engines, if they were breaking traffic laws, they wouldn't actually be able to use the defence of necessity, because this judge thought that they would not actually fit the Shaler criteria in responding to an emergency. Now, if you have a look back at your Shaler criteria now, you can decide for yourself. This judge is far superior in legal knowledge to me, so who am I to argue? But actually, I'm not sure I completely agree with this point. I think, for me, they would be doing what they did to avoid consequences that can otherwise be avoided. They wouldn't be doing more than was reasonably necessary for that purpose, and the evil of speeding wouldn't be considered disproportionate to many emergencies. I mean, I suppose there are some where it would be considered disproportionate, but if it was a house on fire or something, then to me a speeding fire engine is not disproportionate to that. So I'm not sure if I agree, but this is a point that has been made by, like I said, someone far superior, so it is a point that you can make. Secondly, there's very little difference between duress by circumstance and necessity. And in Shaler, the quote that the judge used was that the distinction between the two has been ignored and blurred by the courts. So there's confirmation that there's not really a huge difference between the two defences. So what is the point in having two defences that are so similar? I've given an example there. If you've got a prisoner who breaks the law by escaping prison, but he's done so because it was on fire, he would be able to use the defence of duress of circumstance. So why do we need this defence of necessity as well? In practice, almost all of the necessity cases have been medical cases. And that takes us on to our third criticism, and that is that the main difference between the two is that since the case of Re A, necessity does allow itself to be a defence for murder, whereas the defence of duress by circumstance is no defence to murder. So this hasn't always been the case. In Dudley and Stevens, when they tried to use necessity as a defence, they were told that they couldn't, because necessity is no defence to murder. They couldn't value their life above somebody else's. But when Re A came along and the courts wanted to allow these doctors to separate the twins, they had to distinguish it and make it different. And so the way that they distinguished it was on the basis that in Dudley and Stevens they chose Parker the cabin boy to kill and eat, whereas in Re A the doctors did not choose Mary to be the victim. Instead it was just that they were going to separate them and she would tragically die. But she hadn't been effectively chosen to be the victim. So there's a couple of ways that you could go with that last point. You could criticise that they basically made that distinction because they wanted to allow the doctors to perform that operation and changed the law as a result. Or you could go the other way and say that by making that change, they did create a distinction between the two defences, and they allow medical operations to go ahead that may not otherwise be able to. Right, and that's it for evaluating duress and necessity.